Hello dear students, my name is Dr. Rashmi Nagpal, presently Dean at Geeta Institute of Law, Panipat. Our institute is affiliated to Kurukshetra University and approved by Bar Council of India. Today, I am here to discuss with you the module on judiciary under Indian Constitution, that is lesson 31, which comprises of powers, jurisdiction and procedure relating to Indian judiciary. Which comprises of Supreme Court, High Court and the subordinate courts. Introductory part about judiciary, that it plays very important role in interpreting, applying the law and also adjudicates upon the controversies between one citizen and another and between a citizen and state. In a country with a written constitution, courts have the additional function of safeguarding the supremacy of the constitution by interpreting its provisions and ensuring that all authorities are within the constitutional framework. In India, we know we have an independent and integrated judicial system. Judiciary also has the significant function of protecting and enforcing the fundamental rights of the people guaranteed to them by the Constitution. Unlike other federations, India has a single and unified judicial system for the entire country. There are high courts at the state level. Under each high court, there exists a system of subordinate courts. This means that entirely we have an integrated and an independent judicial system. Then, judiciary under the Indian Constitution is our topic for discussion. In India, as we have seen, we have an independent and integrated judicial system. What are the provisions which make it independent? What are the provisions which make it integrated judicial system shall be the topic of our discussion today. There are provisions with regard to the judiciary under the headings which comprises of Union Judiciary, which is Supreme Court of India under Articles 124 to 147 of the Constitution, State Judiciary, that is the High Court of each state, Article 214 to Article 237 of the Constitution, talk about the jurisdiction, power and procedure of the High Courts. Then about starting with first and foremost, the apex body, that is the Supreme Court of India. I think no need to mention, and everyone knows about it, that Supreme Court of our country is the apex body in the judicial hierarchy of the country. It is the supreme interpreter of the Constitution, a guardian of fundamental rights, the ultimate court of appeal in all civil and criminal matters, and also an impartial authority to decide the disputes between the center and states or the states inter se. When we talk about the composition, the Supreme Court of India consists of a Chief Justice, and until Parliament may by law prescribes a larger number, not more than 7 other judges, that is prescribed in Article 124 Clause 1 of the Constitution. Then the rules made by the Supreme Court regarding composition may fix the minimum number of judges who are to sit for any purpose, that is Article 145 Clause 2 of the Constitution. About the composition, another thing that is important is we must know that no judgment or opinion is delivered by the court except with the concurrence of the majority of the judges present at the hearing of the case, though a judge not agreeing with the majority view is entitled to deliver a dissenting judgment or opinion that is provided in Article 145 Clause 5 of the Constitution. The Constitution, going with the composition again, the Constitution does not provide for the minimum number of judges that will constitute a bench for hearing in any case. Next is that at least 5 judges bench is required to decide a case involving a substantial question of law, What is substantial question of law is decided according to the facts. As to the interpretation of the Constitution and for hearing a reference by the President under Article 143. In other matters, the rules made by the Supreme Court may fix the minimum number of judges who are to sit for any purpose. The concurrence of the majority of judges present at the hearing of the case is necessary for any judgment or order when a bench consists of 2 judges and they differ. The matter is to be referred to the Chief Justice for constituting a larger bench that is provided in Article 145 clause 3 again. Initially, the strength was 7 judges, the strength increased to 17, and now presently the sanctioned strength is 31 of the Supreme Court, including the Chief Justice of India. Appointment, when we talk about the appointment of judges, that every judge of the Supreme Court is appointed by the President of India after consultation with other judges, such other judges of the Supreme Court and High Courts of states as the President may deem necessary for the purpose. That is provided again in the constitutional provision, Article 124 clause 2 of the Constitution. In the matter of appointment of a judge other than the Chief Justice, consultation of the Chief Justice of India by the President is obligatory. About the qualification, which is an important aspect of Indian judiciary, to be a judge of the Supreme Court, one must be 1. A citizen of India, has been a judge of a High Court at least for 5 years, or has been an advocate of a High Court for at least 10 years, and is a distinguished jurist in the opinion of the President. Tenure is different for Supreme Court judges and for High Court. For a Supreme Court judge, he retires at the age of 65 years and he may also resign from his office. When we talk of removal of judges of Supreme Court specifically, is not an easy task as per the provisions of the Constitution. Impeachment is a process. What is impeachment is that a judge of the Supreme Court can be removed by the President from his position only on the ground of proved misbehavior or incapacity. If a resolution in this regard is passed by the Parliament, supported by 2/3 of the members present and voting in each house and the majority of the total membership of each house. The provision relating to this impeachment process, which leads to removal of any judge, is provided in Article 124 clause 4 of the Constitution. The procedure for the presentation of an address for investigation and proof of the misbehavior or incapacity of a judge will be determined by the Parliament by law. The provision relating to this particular provision is provided in Article 124 clause 5 of the Indian Constitution. For this purpose, the Parliament has enacted Judges Inquiry Act 1968, under which the procedure for the investigation into the misbehavior or incapacity of a judge shall be done by a committee constituted by the Speaker of the Lok Sabha or the Chairman or the Rajya Sabha, as the case may be, if the Speaker or Chairman admits the motion after consulting such other persons as he thinks fit, and after considering such materials, if there are any, as are available to him. The leading case is K. Veeraswamy versus Union of India. The case, in this case, a 5-judge bench of the Supreme Court by a majority of 4:1 has held that a judge of the Supreme Court and High Court can be prosecuted and convicted for criminal misconduct. What is criminal misconduct? The expression misbehavior provided in Article 124 clause 5 includes criminal misconduct defined in the Prevention of Corruption Act. The expression public servant in the Act includes the judges of the High Courts and the Supreme Courts. So, the word criminal misconduct not been defined in any of the provisions of Indian Constitution, but provides for the expression misbehavior would include criminal misconduct for the removal of a judge. In every democratic country, as we know, swearing by rule of law, special provisions are therefore made, making removal of judges an extremely difficult task. The security of tenure of the Supreme Court judges has been ensured by this provision of the Constitution. In Britain, for example, the judges hold the office during the good behavior and can be removed only on an address from both houses of parliament. In the USA, the judges of the Supreme Court hold office for life. They can, however, be removed by impeachment in cases of treason, bribery, or other high crimes and misdemeanors. So, we differ from these provisions as regard Indian Constitution is concerned. About powers and functions of the Supreme Court, we talk about first and later the High Court. The three types of jurisdiction, that is original jurisdiction under Article 131, 132, appellate jurisdiction and advisory jurisdiction. Under Article 143 is the advisory jurisdiction given to the Supreme Court. Further divided into the appellate jurisdiction, appeal in constitutional matters, that would lie under Article 132 clause 1. Appeal in civil matters would lie under Article 133. In criminal matters would be Article 134, and special leave to appeal provided in Article 136 of the Constitution. Then further is the division which we shall discuss later. What is original jurisdiction? The question arises now, the most important, what is original jurisdiction is provided in Article 131, which talks about the Supreme Court can settle disputes, one, between the center and one or more states, two, between the center and any state or states on one side, and one or more other states on the other side. 3 is that it can be between two or more states. But the question arises, will this original jurisdiction extend to all matters? The answer remains no. The original jurisdiction of the Supreme Court, however, does not extend to the following matters which are given. 1. It does not extend to a dispute arising out of any treaty, agreement, covenant, engagement or other similar instrument which was executed before the commencement of the Constitution and continues to be in operation, or which provides that the jurisdiction of the Supreme Court shall not extend to such a dispute. The proviso to Article 131 of the Constitution talks about this provision. Second is that Article 264 of the Constitution provides Parliament may by law exclude the jurisdiction of the Supreme Court in disputes with respect to the use, distribution or control of the water of any interstate river or river valley. This is an important provision with regard to the water disputes that are happening in India. Number 3, as Article 280 provides, the matters referred to the Finance Commission. Article 290 is the adjustment of certain expenses between the Union and the states. More on original jurisdiction is that the Supreme Court in its original jurisdiction cannot entertain any suits brought by private individuals against the Government of India. The dispute relating to the original jurisdiction of the court must involve a question of law or fact on which the existence of legal right depends. This means that the court has no jurisdiction in matters of political nature. The term legal right means a right recognized by law and capable of being enforced by the power of a state, but not necessarily in a court of law. Enforcement of fundamental rights. It has been given the power, the Supreme Court has been given the power under Article 32 which confers original jurisdiction on the Supreme Court to enforce fundamental rights. The Supreme Court is given the power to issue directions or orders or writs in the nature of 4 writs, that is, namely habeas corpus, mandamus, prohibition and certiorari, whichever may be appropriate in the relevant case. Appellate jurisdiction. Appeal in constitutional matters is one while we talk about appellate jurisdiction. That is, Article 132 Clause 1 provides for appeal in constitutional matters. An appeal shall lie to the Supreme Court from any judgment, decree or final order of a High Court, whether in civil, criminal or other proceedings, if the High Court certifies under Article 134A that the case involves a substantial question of law as to the interpretation of the Constitution. When we talk of appeal in civil matters, we refer to Article 133 of the Constitution. In a civil case also, an appeal can be made to the Supreme Court against a decision of the High Court. Article 134 of the Constitution provides for the appeal in criminal matters, which states that an appeal lies in the Supreme Court against any judgment, final order or sentence given by a High Court in the following 2 ways. Without a certificate is Article 134 Clause A and B. With a certificate is Article 134 Clause C. Another provision is, that is an important one, deals with special leave to appeal. That is Article 136 of the Constitution. It vests in the Supreme Court a plenary jurisdiction in the matters of entertaining and hearing appeals by granting special leave against any kind of judgment or order which is made by any court or a tribunal. The tribunal here will not include any order passed by a military tribunal in any proceedings, and the exercise of this power is entirely left to the discretion of the court, unfettered by any restrictions. So, under special leave to appeal, Article 136, the only exclusion is the decision by a military tribunal. Next is the advisory jurisdiction under Article 143. If at any time, Article 143 goes as, if at any time it appears to the President that 1. A question of law or fact has arisen or is likely to arise, and b. The question is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question for the advisory opinion of the court, and the court may, after such hearing, if it thinks fit, report to the President its opinion thereon, making it an important jurisdiction by the name of advisory jurisdiction, advise to the President. Under Clause 2, if the President refers to the Supreme Court the matters which are excluded from its jurisdiction, under the proviso to Article 131, the court shall be bound to give its opinion thereon. And an important case is the re-presidential poll of 1974. Court of record is another important provision relating to when we talk of Supreme Court. Article 129 talks about the Supreme Court also acts as the court of record and confers all the powers of such a court, including the power to punish for its contempt. The judgments of the Supreme Court are recorded and considered as authoritative and serves as cases, laws and proceedings. These cases, these judgments have an important evidentiary value. This extraordinary power must be sparingly exercised only where the public interest demands. Then Article 137 is the review of judgment and order. The Supreme Court is empowered to review any judgment given by it earlier. It can do so if 1. some new facts or evidences appear, a fault is found according to its own record, and there are sufficient reasons for review, then only in Article 137 there can be a review of judgment and order. When we talk about another important provision is Article 142 and 144 is the enforcement of decrees and orders of the Supreme Court. The Supreme Court under Article 142 in exercise of jurisdiction may pass such decrees or orders as is necessary for doing complete justice in the matters pending before it. The decree or order which is made by the court shall be enforceable throughout the territory of India in such a manner as may be prescribed by or under any law made by Parliament. Until provision is made by Parliament, the orders of the court will be enforced in the manner prescribed by the President. Then Article 144 is again related to the similar provision that all authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court, which is the guardian of the Constitution. The Supreme Court of India is regarded as the guardian of the Constitution. It is the supreme or final interpreter of the Constitution. The interpretation of the Constitution given by the Supreme Court has to be respected. Under Article 141, law declared by the Supreme Court shall be binding on all courts, making it ensuring that it is the guardian of the Constitution. Another important aspect that deals with the Supreme Court is the public interest litigation, that even if a victim or affected party does not file the case, anyone from the general public not involved in the case may file a litigation or a lawsuit if it is in the general public interest, and it is the privilege of the court to entertain or not to entertain the application for the public interest litigation. Then this is all about the Supreme Court of India, the powers, procedure and the composition. Then is the state judiciary, that is the high courts under Article 214 to 237. The judiciary in state consists of a high court and a system of courts which is subordinate to the high court. The high court, it's the Constitution Article 214 to 14 provides for a high court in every state which works under the Supreme Court of India. However, under Article 231 clause 1, the Parliament can establish by law a common high court for 2 or more states and a union territory. The composition as far as the high court goes, Article 216, that it consists of the Chief Justice and such other judges as the President may appoint from time to time. Appointment of high court judges is in the provision Article 217 of the Indian Constitution. The judges of the High Court are appointed by the President of India. The President appoints the Chief Justice of a High Court after consultation with the Chief Justice of India and the Governor of the state. Article 215 provides that it shall be a court of record. Every High Court shall be a court of record and shall have all such powers of such a court, including the power to punish for its contempt. The scope and nature of the power under this article is similar to the powers of the Supreme Court under Article 129. There is a provision for additional and acting judges. The President may under Article 223 appoint one of the judges of the High Court as acting Chief Justice when the office of the Chief Justice falls vacant, or he is unable to perform his duties by reason of absence or otherwise. The President may appoint duly qualified persons to be additional judges of the court for a temporary period not exceeding 2 years in order to clear off the areas of work in a high court. Also, the President may also appoint an acting judge when any judge of a high court other than the Chief Justice is unable to perform his duties by reason of absence or any other reason, or is appointed to act temporarily as the Chief Justice. For the qualifications of a High Court judge, 1. He is a citizen of India. 2. He must have held for at least 10 years a judicial office in the territory of India, or he must have been for at least 10 years an advocate of a high court. Tenure is different as compared to the Supreme Court judges. A judge of high court retires at the age of 62 years. He may also resign from the office at any time. The removal. The president may remove a judge of a high court on the ground of proved misbehavior or incapacity. Jurisdiction of the high court is divided again into three parts: original, appellate and administrative jurisdiction. Original means that under the original jurisdiction, a high court has the power to issue directions or orders including writs, Article 226, corresponding to the Supreme Court Article 32, to any person, authority and any government within its jurisdiction against the violation of the fundamental rights of the citizens. It has limited original jurisdiction in cases relating to admiralty, will, divorce, marriage, company laws and contempt of court. Clause 4 of Article 226 provide that the powers conferred on a high court shall not be in derogation of the powers conferred on the Supreme Court under Article 32 of the Constitution. When we talk about appellate jurisdiction, a high court has the power to hear appeals about civil and criminal cases against the decision of the lower courts. Administrative jurisdiction would mean that a high court has the authority to supervise the workings of all subordinate courts. It can issue general rules to regulate their proceedings. The judges of the subordinate courts are appointed, promoted and transferred in consultation with the High Court of the state. About subordinate courts, all the subordinate courts function under the supervision of the concerned High Court. The court of the district judge is the highest court in a district. The judge is called the district judge while dealing with the civil cases and session judge while dealing with the criminal cases. Besides these courts, there are courts of assistant judges, sub-judges, munsifs and courts of small causes. The High Court has been given control over the district courts and the courts subordinate thereto, including the postings and promotions of and the grant of leave to persons belonging to the judicial service of the state and holding any post inferior to that of the district judge. The recent development in this regard, that is, we compare the provisions of the 2014 bills with that of the 2013 bills and the recommendation of the standing committee in this regard. About the new National Judicial Appointment Commission Bill 2014. One, about prescribing the composition and functions of the commission. The composition and functions of the JAC, that is the Bill 2013, should be included in the Constitution. The procedure to be followed by the JAC may be determined by law made by the Parliament, and in this case, for the recent bill, the recommendations of the standing committee has been incorporated. Then when we talk about the members of the commission of NJAC 2014 bill, it is the composition remains unchanged with 6 members, that is, it would include eminent persons also, and however, it adds that one of the eminent persons shall be nominated from among the scheduled caste, scheduled tribes and other backward classes and minorities. Then the functions have been included in the Constitutional Amendment Bill 2014. The President may, the Chief Justice of India, the NJAC shall recommend the senior most judge of the Supreme Court for appointment as Chief Justice of India. This is provided he is considered fit to hold the office. Then procedure for selection of the High Court judges and procedure of selection of the Supreme Court judges is provided in the National Judicial Appointment Commission Bill 2014, which is a recent development and a major step to ensure the independence and integrity of the judiciary, going away from the collegium system. Then reference to commission for filling up of vacancies is also provided. When a vacancy arises in the High Court or the Supreme Court, the central government will make a reference to the NJAC, that is National Judicial Appointment Commission, and it provides for two more provisions relating to that. When we talk of judicial review, an important feature is a special power of the Supreme Court and the High Courts in India to scrutinize whether a law passed by the legislature or an action taken by the executive is in accordance with the provisions of the Constitution or not. If it is found that such a law is or an action is not in accordance with the Constitution, then it can declare that as uninvalid and unconstitutional. Then the concept of judicial review originated far long time ago in the United States of America case of 1803, Marbury versus Madison. About judicial activism, the court has now begun to intervene in it questions the activities of the executive and the legislature, reminding them from time to time of their duties and responsibilities to the societies. Thereby, we call it the guardian of the Constitution. The beginning of judicial activism in India could be traced back to 1985, when the then Chief Justice of India, Justice P.N. Bhagwati, converted a letter written to him on a postcard by an aggrieved person into a public interest litigation. About more on judicial activism. By the middle of 1990s, judicial activism became more and more pronounced. It has passed landmark judgments over environmental degradation, pollution control, preservation of historical monuments, eviction of unauthorized occupation of government buildings, etc. and so on. In this way, we can say that the judiciary has become overwhelmingly busy with the cases brought before it from various quarters of the society, and the activism of the judiciary is remarkable. It has benefited the common people in terms of addressing their grievances to a large extent. All about this judicial activism, an important feature, judicial review. We have learnt till now that Supreme Court is the apex body of our judicial system, and then we follow the hierarchy of the courts below, High Court and then the subordinate courts. We have certain provisions in the Constitution which ensure that the integrity and independence of the judiciary is maintained. We can conclude from the foregoing discussion has become now a guardian of the Constitution, thereby that the new bill NJC 2014 ensures further that the judiciary is independent, and the collegium system followed for years together, which finds no place in the Constitution, has been scrapped. We have learnt till now in the discussion, foregoing discussion, about the Supreme Court, the powers, procedure and the jurisdiction, which are the provisions which the makers of the Constitution envisaged to make judiciary free from executive and legislature control, but as a watchdog for the implementation of all policies, thereby helping by way of public interest litigation all those weakened section of the society who was not able to come forward with the complex process of litigation. We have learnt about the procedure, powers of High Court and its jurisdiction, and thereby we have learnt today that the powers of judicial review and the judges, the courts' judicial activism has benefited the common man in addressing the grievances to a large extent. Thank you.